그 이야기를 하는데 지금 이야기 아직은 안 하는 상황인 것 같습니다. 아니면 채팅을 여기에서 이야기를 해도 되고요. 기다리는 상황인 것 같아요 지금.
얘기하시고
이게 그 돌아다니면서 일어나가지고 돌아다니면서
예. 좀 말 걸어볼 수 있겠네요.
예. 근데 지금 다 기다리는 상황인 것 같아요. 약간 나갈 수도 있습니다. 여기 나갈 수도 있고요. 근데 여기에서 사는 사람들도 있어요. 예.
근데 생각보다 그런 사람이 많은데.
그리고 이 화면을 그 VR로 봐요. 그러니까 지금 여기는 VR이 아닌데 VR로 보게 할 수도 있습니다.
남자구나. 예쁜 여자. 근데 문제는 별 사람들이 다 많을 것 같은데.
응?
별 사람들이 다 많을 것 같아요.
별 사람?
베리어스 피플.
아니요, 이 사람들 다 교육자들이에요.
그래요?
예. 그래서 아시는 분 있으신가요?
알 수 없죠.
네.
너무 잘한데.
지금 제가 관심이 있는 건,
슈퍼챗.
왜 앉으셨군요. 일어나면, 관심이 있는 건, 이메일들이, 그러니까 한국에서는,
괜찮은데요, 이거?
예, 한국에서 말 안 하는 이야기, 예를 들어 홀로그램은 아무도 이야기를 안 하잖아요.
그렇죠.
근데 이 사람들은 지금 홀로그램 이야기를 아주 많이 하고 있습니다. 그래서 그런 교육적인 그러니까 한국적인 상황은 이렇게 정치적인 도움을 안 주기 때문에 스마트 이야기를 안 하는데, 얘네들은 ICT라는 이름을 써요. 스마트폰도 아니고 ICT로 계속 쭉 해서 이 사람들은 ICT의 한 분파에서 지금 세컨드 라이프를 활용을 하냐 마냐 지금 제 페북에 지금 보시면 지금 거기에서 지금 이야기하자라고 지금 모인 사람들입니다.
그렇겠네요.
네, 근데 지금
제가 건너면 안 될까요?
아니요. 왔다 갔다 안 하고 어디 구석에 앉아있기만 하면은 괜찮을 것 같은데 왜 이야기를 안 해?
아닌 게 아니라,
이 사람이 지금 그 이야기를 하는데, 이 오렐리라는, 이거 보였네요? 이제, 그거 하나 보였습니다. 뭐죠? 발표, 예. 아이고, 하나.
앉아서 봐야겠는데.
예. 이게 외국에서는 무기 시스템으로 됩니다. 그리고, 이제, 말을 왜 안 해? 무기 이런 형식으로 지원이 돼서 사람들이 무기 이걸로 봐요. 한국에서 지금 CU랑 또 다른 한 기업이 이거를 사놨어요, 땅을.
회의도 얘기하면 저기 아니고.
그러면 이걸 끄면 됩니다, 마이크를. 마이크 꺼놓고. 네, 아니.
Hello, everybody. I'm sorry we're starting a few minutes late. My name is Tim Faith, and I am the president of the Bar Association. And originally, I was expecting Agenda Firmat to be here today to do this presentation, but I haven't heard from her this morning. And I'm wondering whether she ended up with a scheduling conflict. She is a practicing attorney in California, and recently took over. She's a committee chair, I believe, for one of the IP sections committees for the ABA, and it may just be that she wasn't able to make it on this morning. I noticed she actually hasn't been enrolled since last month, and we had talked about this presentation for her doing it probably 2 or 3 months ago, so it's possible she just couldn't make it in. Yeah, if you're having sound problems, there's a little pause button that's up, at least in the Firestorm viewer, in the upper right-hand corner. It's not too far off from your volume. Can everybody else hear me okay? Okay. Well, I'm going to cover for agenda, and we'll talk about trademarks today, particularly with a focus on Second Life creators. And that if you have any questions that you have about trademarks, you're welcome to ask me. And if I don't know, we can certainly ask agenda and see if we can't get back an answer to that question. As I said, I'm the president of the Bar Association. I am a practicing attorney in Maryland, and I'm also a college professor now at the Community College of Baltimore County. I also teach as an adjunct at Maryland Institute College of Art and in the graduate program there. And I do talk about IP issues. Intellectual property is a part of my law practice. And I have 5 trademark applications for really old clients. I don't have any Second Life clients where I've worked on trademark matter for them, but nonetheless, I have some familiarity with the trademark area of the law. And that's where we're going to start today. So I have a few slides that I wanted to offer first, which sort of talks about the law, at least in the U.S. law, and then we can kind of enter into more of a discussion about how it works in Second Life. If you have questions as we go, feel free to put them in local chat, and I'm happy to try and help answer them. There are probably millions of in-use active trademarks just in the United States for products and or services that are offered for sale. Fundamentally, trademarks and the protection of trademarks is about knowing who is the originator of a good or a service, who made it. And the mark is supposed to uniquely identify the originator of the product. So the issue with trademarks, I think, in part, is without them, we would really struggle, I think, to know what we're buying as consumers. If you think about a bottle of Coca-Cola, it's just a dark, liquid, fizzy substance. And if you went to the grocery store to buy Coke, but there were no labels that told you which bottles to buy, all the soda products would pretty much look the same. I mean, obviously ginger ale is a lighter color and Sprite, but without actually being able to taste, and in fact, probably more times than not, you might not know the difference between Coke, Pepsi, and something else merely by its taste. So the trademark really serves an important purpose, which is to tell you who made it. You know, sort of what you're getting, what the quality or the type of product it is that you're going to get. And so they serve an important purpose in the economy today. But we've had trademarks for a very long time. Well before there was the United States, there have been trademarks, and they've been used in commerce as far back as we know in ancient origins, even in Rome, that craftsman in Rome would
The
uniquely
mark is
mark
supposed
their
to
goods,
uniquely
whether
identify
pot or
the
the
originator
item
of
they
the
might
product.
make, so you would know the originator of the good.
So
in the Middle
um,
Ages, shipwrecks were a lot more common than they are today because, for one thing, there was no weather service in the 16th century. There weren't really very good, reliable maps, particularly of local channel problems. A weather situation could blow up rather quickly and cause a ship to crash ashore. And one of the things that, at least in the British system, if you had goods that crashed ashore and they weren't marked, the king would be able to take those. They would be able to take those goods essentially as a tax. And so merchants would routinely mark their goods on ships so they would be recoverable and have a claim against the king, to not take the goods that had crashed on shore. In guilds, which also are a Middle Ages invention, there were trademarks in use or marks in use that would uniquely identify the craftsperson within the guild that made an item. And generally, guilds were set up around a particular product, and membership in the guild meant that you had access to what today would be called trade secrets, that is how to make the good, whatever it might be, whether it was a gold item, whether it was a basket or some other craft or different state level protections. But the Lanham Act today is the starting point for protection of trademarks under federal law, in the United States. Importantly, though, the Lanham Act only protects marks that are used in interstate commerce, that is, when goods or services are sold across state lines. When you have a mark that's only used within a state, then it can only be protected by that state's statute or common law. When you have a mark that's protected under the Lanham Act, it also may, in addition, be protected under the state where the infringement occurred or where it was in use. And that's what the state unfair competition laws, which are common law torts, in addition with state statutes that may govern protection of trademarks, come into play. Because of the way that our federal system is set up, it is possible for state law to not be preempted by federal law, to actual additional protections. And this is exemplified in part by the dilution statutes, the trademark protection. That was not an original part of the Lanham Act, as I recall, but was added later. But there were states that protected trademarks from dilution, and that means something a little bit different than it might under federal law, depending on the state that you're talking about. So it's possible you could have additional protections under state law. Trademarks themselves, there's some nuance to what's protected and what isn't. So even if you're using a unique identifier in common, the most protection, usually an arbitrary mark is a made-up word, or it's a word used with something that's usually not associated with that word. It really doesn't describe the product or even allude to what the quality or the service is about. It is usually just completely unrelated as an arbitrary mark. And then there are, sort of in the middle, there are suggestive marks, which suggest the either an attribute of the product or suggest the quality of the product or something related to what the product or service is about, but is not directly descriptive of it. So, for example, a generic or merely descriptive mark, you might take, for example, if I had a parking lot and I called it the parking lot, that is probably generic or perhaps merely descriptive of what you get, the service that you get when you park on my lot. Not a very good trademark. Xanax, on the other end of the scale, is an example, I would say, of an arbitrary mark. It's a made-up word. It doesn't tell you really anything about the product or the service that is involved. And, as a consequence of that, receives a lot out of that product or service. And then finally, on my chart here, I have thermos as a generic mark. And I talk about this because the thermos case actually came out in the 40s. And the reason why thermos is generic is not because the word was not made up. In fact, thermos is really not a word. The people that made thermoses, were one of a number of manufacturers of vacuum-sealed tubes, and it doesn't really literally describe the product. It really doesn't have, it might not even be suggestive of the product. It's sort of an unrelated, made-up word. But the problem with thermos, and today everybody uses thermos, even though it is in fact a brand name, and there is a manufacturer that is called Thermos still. You can buy them. But the reason why it's generic is that, as a matter of law, they had gotten so popular that the general public just simply associated the word thermos with any vacuum-sealed tube that kept, hot liquids hot or cold liquids cold. Stanley makes thermoses today, but pretty much everybody calls them by the category of thermos as opposed to a Stanley brand or a Thermos brand vacuum-sealed tube, which no one says that. And the reason why a mark becomes generic is not because it started out that way. Usually it's a popular mark that gets so closely associated with the category of goods in the mind of the public that everybody just uses it, not as a trademark at all anymore, but just simply to indicate the thing that you're buying. Kleenex is another one of those that has the risk of being generic. Onesies, even though that is a brand, everybody that has a child calls every one of those one-piece items of clothing with snaps a onesie. So they run the risk of becoming generic because of the public's approach to the mark. And it's interesting because you normally don't think about your rights as being changeable by the public or the usage of the public. But property rights in particular, at least in U.S. law, are like that. And real property has the same kinds of scenario. If you continuously mow your neighbor's yard for 20 years in Maryland, if your use of that land becomes open, notorious, and exclusive, your right, which starts out as really a trespass, can become a title to that property under adverse possession, if you can demonstrate all the elements of adverse possession. And it's the same, I think, that trademarks that started out as exclusive and the property, intangible property of a business that makes a certain product, if they're not careful about protecting the mark eventually could become generic if the public uses it that way. And so it's important that it's responsive to how the public views the trademark, how it uses the trademark. And I would say Google is another one of those that's at risk, even though the Google people have been somewhat careful about protecting the brand. But a lot of people say, I'm going to go Google it. They don't say they're going to Yahoo it or Bing it or Alta Vista it. They say they're going to Google it. And that doesn't necessarily mean that they're going to use Google to find the website. It's become more of a category for web searching for some in the public. And so there is a risk that Google might go the same way because of its enormous popularity. that you have that same problem, potential problem with it. Well, I don't know that they have, because Google as a brand is still in use, even though Alphabet is actually the holding company of the different businesses that started out as a search engine that started to do other things. My impression from the news is that Google transferred itself into Alphabet because they wanted independent divisions to be separately profitable. And that all would go up to the holding company. So if you use Google Docs or use Google Apps for Business, that would be a separate business from the search engine and would have to be separately profitable from the search engine. Alphabet clearly does not describe search engine products or services and isn't used by the public like the word Google is in association with search engines, so it doesn't have the same problem. But I'm not really sure that the IP issues were the reason. I think they did their corporate restructuring for financial reasons and management reasons of their different products and services. So with regards to trademarks, you may not use someone else's trademark. And you also may not use a mark that is confusingly similar to an existing trademark in commerce. The reason why this is the standard is that it is from the public's point of view whether a particular trademark confuses the average consumer about who made the good or the service. It's from their perspective. The purpose being so that when consumers go out and buy a good or purchase a service, they know who's going to make it or who is the originator of it. Now, we're used to internet domains that you can register an internet domain that's pretty close to an existing one. You know, if you put a dash or some other punctuation, for example, or maybe you spell it a little bit differently, and that's cool. You know, the web DNS services are very exacting about, the syntax that you use to find a website. And they permit things that are very, very similar to each other to be registered and owned by different people, used really with completely different products or services potentially. But the trademark system doesn't permit that. It would not permit closely similar marks being used by different people in commerce, particularly when they're associated with a similar category of goods or services. That's really what confusingly similar is about at the federal level. It's using the same or similar trademark on a same category of goods or services. When you are not the same as the originator, that is confusingly similar. And so there's a fuzzy logic about what constitutes confusingly similar. Usually what courts look at is a multi-factor, which is similar to the defendant's mark in products that are in a similar category. Those first three factors there often will cause a mark to be confusingly similar. But courts also look at other factors and weigh all the factors together. And you see in legal tests where there's these balancing tests, having 8 factors usually tells you that there's a lot that courts consider in the legal definition of confusingly similar. This is a highly fact-specific and a relatively nuanced area, whether a mark is confusingly similar or not. But I can tell you that if you're trying to register a trademark, generally speaking, the trademark office examiner only really considers the first 2 or 3 factors. They aren't going to really look at the others when they refuse a registration at the USPTO. It has a lot to do with the similarity of the marks compared to an existing pre-registered or pre-existing registered mark, and the category of goods or services. If you're in the same category and you have a similar mark, it's not going to get registered. It's very difficult to get the trademark office to agree to do that. Even if you might argue the other factors are in your favor, if you have those acts, it doesn't do the trademark office. They really are looking at really the first two or three that are the issues for them. Now, as I said, trademark law also protects against dilution. It's unrelated to goods or services. It has to do at the federal level with famous marks. Famous marks may not be used by someone other than the owner of the famous mark. So Coca-Cola is probably a famous mark. The statute talks about what that means. In terms of how long it's been around, if it's known nationally, there's a variety of factors to define famous. But famous marks you just can't use even in unrelated goods or services because of the way the dilution statute works. And some of the cases are about a well-known mark holder that doesn't want to be associated with something they consider unsavory. There was a case at Pillsbury where its marks were being used by a pornography film, and they sued for dilution. Obviously, no one's confused about people that make bread products with a porno maker. It's not that the goods are similar. It was that the Pillsbury people did not want to be associated with pornography. And they can sue because it doesn't matter whether the products are related. It's really the use of the famous mark without permission that's the problem for that. So that's an alternative cause of action under federal law for the use of someone else's mark, but requires evidence that the senior mark is a famous mark. Now, the monopoly rights that are granted to an owner of a trademark are not absolute. Besides the fact that they have to be used in commerce, and if you register a mark, generally you have to maintain the mark with the USPTO to enjoy the benefits under federal law. But there are certain defenses, nominative and classic fair use, and concurrent, but the unregistered prior user is another potential defense. Also, just whether the mark itself could be used as a mark under federal law, there are limitations by statute as to what you can register as a mark, beyond the confusingly similar standard of the dilution issues. There's just certain marks that can't be used as marks under federal law. For example, the name of a living president without his or her permission. You can't use the flag of the United States as a trademark. There's other things that are specifically prohibited under the federal statute. Fair use has to do, the classic example of fair use is when you're comparing products, like if Downy and Tide, there was a commercial about fabric softener, and the Downy people are comparing themselves to Tide, saying, we make the clothes you wash with us softer than Tide. That's a comparative use. And usually that's permitted under fair use as kind of a classic comparison. That there's no confusion that consumers are going to say, oh, Tide made the commercial, it's really about Tide. No, it's the Downy people saying the product is better than Tide. And that's generally looked at as permitted under federal law. There are also fair use defenses. Sometimes when people make fine art, it's possible that they could enjoy a fair use defense. That Tom Forsyth was sued by Mattel. Tom Forsyth had made all these sculptures that he'd photographed of Barbie dolls in various poses, some headless, some in soup. I mean, they were intended as a criticism of the Barbie doll. And Mattel didn't like it. They sued for use of their trademarks without permission. But ultimately, Forsyth won under fair use. Even though the mark was clearly being used by him, the courts looked at balancing that against his First Amendment rights to speak and decided that no one was confused or thought that Mattel was endorsing his work. So therefore, there really wasn't a trademark infringement issue. But again, most of the time, those are unusual situations. I'd say by and large you're taking your chances with using someone else's mark, particularly a registered mark. There is a registration system that was part of what was provided for under the Lanham Act, and you can take a mark used in commerce or one that you're anticipating to promptly use in commerce. You can register those with the U.S. Patent and Trademark Office, which is a federal administrative agency. And they actually, you can do it online. They provide a form that you can fill out electronically, where you can identify the mark, you can identify the goods or services it's associated with, its description, and so on. And so there is a way to do that. If you have an intrastate only mark, which almost never would apply in Second Life, but in real life you might have a mark only used locally. Most states have their own state-based registration system. Maryland's, the Secretary of State is the entity that is responsible for registering intrastate marks in Maryland. Other agencies at other states are the responsible entity for that. They have their own system for registering and keeping track of marks. Registration is not free. It is actually somewhat expensive to do, and it does usually take some effort to make sure the mark can be registered. There are plenty of people that don't use an attorney for registration, but I would say more likely you're going to reduce the chances of having an office action or get your mark just turned down, and being able to do anything about it if you go through clearance process with an attorney to help you with the registration process. But again, it is set up, and there are plenty of people that do it on their own to register a mark. It's a few $100s typically to register it with the USPTO. States are usually less. I think Maryland's $50 as a filing fee. But there are benefits to registering with the USPTO when you have an interstate mark, and they have to do with some of the remedies that you can get and some of the evidentiary benefits that you get if there's litigation. You don't have to register to sue somebody for infringing your trademark, but under federal law, that usually limits you to injunctive relief. That is an order that tells somebody else to stop using your mark, which may be all you want, but if you want actually to get your lost profits or financial damages out of a trademark infringement suit, you need to have registered with the USPTO prior to filing a lawsuit. Incontestability provides that after 5 years after your mark's registered, that it is conclusive evidence that you own the trademark. Simple registration represents prima facie evidence that's rebuttable, but after 5 years it becomes conclusive, and so the other side can't argue you don't own it. They may have other defenses, but they can't make that argument before the court. And usually the registration itself would be a part of the plaintiff's case in chief to begin with, to explain that I am really the owner of the mark and this is when I started using it in commerce and so on, that the registration does that. So trademarks, are an important aspect of the economy, and I think that, for Second Life, one of the dilemmas is the same real life of life with regards to trademarks. And a big risk you would take is having goods or services here that are really someone else's mark. I remember back in the bad old days when I first joined SL, there were people that sold Rolexes that were misspelled, and they were watches, and they had a lot of bling on them. I'm pretty sure none of those vendors had permission from Rolex, which is a famous brand, to use that mark here in Second Life. And that can get you into a real-life trademark infringement lawsuit, or at least get a really nasty letter, cease and desist letter from an attorney saying, don't do that. You have to promptly stop. So there's that side of it. But the other side of it is that there are a lot of really well-known brands within Second Life There are a number of mesh body creators, mesh clothing creators that have, a pretty large following. I think some of those groups have 20, 30, 40,000 users in them, which is pretty big, within the world of Second Life. And there's real money involved with those. And so there's a real risk to a creator that you become well known here, and then someone starts making knockoffs of your shape, or they make knockoffs and affix a similar trademark to their competitive goods in the marketplace here. And so I think that, not every Second Life creator makes enough money to justify hiring an attorney to, file a lawsuit or potentially even to go through the registration process. But it is kind of advice I give to many small businesses that this is one of those things you want to think about. Everybody has to use a trademark. It's really hard not to and market your product or service. You have to have something. So you want to pick a mark that you like, that you can clear. That is, that we can say with some reasonable certainty it's not currently being used by anybody else, and it's not confusingly similar to an existing mark. And then you want to take the steps to protect that IP like you would if you were a real-life business, which is most likely to register it and then to police that mark's use. And, those issues are the same. I just think that, back in the wild days of Second Life, at the start, people just assumed that federal law didn't apply, or they could do whatever they wanted here because it was a fantasy. But there are, if you're operating a business in Second Life, you make an income here, it would be a part of anybody's business plan, just as if you were operating a brick-and-mortar store in real life, to clear your mark and then to protect your trademark. Potentially from, an unscrupulous competitor or a negligent competitor, using that mark. How does LL put their finger into the issue? Well, I guess there's different ways that Linden Lab itself could be involved. One is they can be sued for vicarious infringement. Because they are hosting the infringing material. And so they have a potential liability if they, vicarious liability standards are relatively high. It's relatively difficult to make another party liable. Generally, it requires proof of knowledge and benefit, from the infringing activities. But they can be named as a defendant. That can be expensive for them to defend. A trademark infringement lawsuit because of some creator in Second Life that, isn't doing what they're supposed to do. I assume that they may also, on complaint, take down infringing materials out of the marketplace and perhaps off a SIM. I know that eBay has been sued on similar grounds when they are offering for sale infringing materials, and I know that eBay does take more effort to police. I don't know how far or what Linden Lab really does with regards to that. I know that there have been copyright claims. There's a DMCA takedown process that goes to Linden to take down a copyright infringing item. There's not the same statute as there was with the Copyright Act for trademarks. But my guess is that if you're a creator and you complain to Linden Lab, that might raise their liability if they take more action in response to that complaint with a competitor that clearly is infringing on a trademark. So Michael asks, if you're a writer who's going to put self-written poetry on photos, should you be concerned about copyright? Well, I guess there's two sides to it. If you are the author of and this is unrelated to trademarks, but if you're the author of the poetry and you're the author of the photos, then that is, if you're the original creator of both, and you offer them for sale in Second Life or elsewhere, You're creating an original work of authorship. Under federal law in the United States, at fixation, it enjoys protection. The issue is if you're not the creator of one or the other, then you have to get a license typically from the person that is the creator, or you run the risk of an infringement lawsuit under copyright law for that. Does that mean that it's automatically protected? Well, no. And generally, in order to file a lawsuit under the Copyright Act, you have to have registered the protected work with the Copyright Office first. That's a prerequisite to the lawsuit, unlike the trademark law. So usually, just like you'd register a trademark, most lawyers would encourage you to also register your copyrights with the Copyright Office for things that you're offering for sale. And you might have to prioritize where the risk areas are and register the most important or the most valuable things first. But again, that's common. And then, if you discover infringement in Second Life, you have the DMCA takedown process with Linden directly. And then alternatively, you have the ability to file a lawsuit against the infringer, if you can identify who they are. And that's okay. It's all intellectual property. We just happen to be talking about trademarks, but copyright patents and trademarks are the three legs of the stool of intellectual property. And there's some other issues in the periphery, but those are kind of the big three topics. So it's all right. It's a related question. Are there other questions about trademarks or concerns about trademarks in Second Life? I see several people typing away, so I'll wait for you. Well, I want to start with the Frank Herbert question. Frank Herbert was the author of Dune. There were actually movies made of Dune. I remember Sting was actually in Dune. I remember watching that movie when I was a kid in the 80s. There's a copyright that's enjoyed under federal law in original works of authorship. And copyright law, in addition to creating a protection against reproduction, also creates a protection against unlicensed derivative works. And so, generally speaking, if you want to make something that's based on an original work of authorship, you need permission. There is a concept of scenes of fare and kind of, if you're in the genre, but you don't necessarily use the plot development of the characters, that may not in fact be copyright infringement when it's just the scenes of fare. But if you decided that you wanted to have a role-playing sim where people were going to experience different scenes from Dune, then Frank Herbert's estate owns the copyrights of his works, And that copyright protection lasts for 70 years after he dies, so it's for a relatively long time. I don't know when Frank Herbert died exactly, but I imagine that's probably well into the middle of this century before that stuff will become the public domain. It's well within their rights to do that. I mean, they have exclusive rights in the copyright. I mean, I don't know that there's as much of a trademark issue with that. I guess you might say there's a brand of Dune. I don't know. I'm not really sure that's in the same area, but certainly there's a copyright right. And it's similar to people that wanted to take the Harry Potter series and do their own fan-sponsored stuff. You know, when you don't have permission to do that, or you're going to profit, you know, run a sim or something like that, then you have a problem with copyright infringement. And the person who owns the exclusive rights has the right to say stop. In terms of your question, do LLTS overstretch their influence? If I create a Rockstar avatar that has an output such as a 3D holographic, what does Lemon Lab Terms of Service say about that? You know, this presentation wasn't primarily about the Terms of Service. I mean, if you create an original work of authorship here, you get the same rights in it here as you would in real life. You know, generally you are the owner of works that you create. There was, in TOS 2.3, there was a concern that Linden was overreaching to try and take ownership of copyrighted materials created in World. I'm not really sure that's been resolved. I know that we had an extensive presentation prior to the 2.3 being revised about concerns about that. And I don't know the answer today in terms of the copyright law. I don't know of any cases that have come up recently about that. Michael, your concern about it would partly be machinima. You know, if you're making an in-world video and then, or if you're making photographs in world and then using it to make your own art. I know that the TS specifically permits machinima. It's really, that cuts across the rights of sim owners generally. So that they can't, by copyright law, prevent you from doing machinima. But, I mean, you know, in theory anyway, I mean, if you were to take a photograph of someone else's sim and you make your own stuff from it, so in theory it's a derivative work, you know, based on someone else's works. Does that mean that it's automatically infringing? I don't know the answer to that. You know, if you, and I've had artists that have come to me in real life, we're taking photographs of famous landmarks in other places, and you know, there are a lot of famous landmarks that have trademarks in them. There are well-known buildings that were built and used by you know, a trademark owner, and the trademarks on the building. And you know, in theory, you have a fair use right to take pictures and make fine art. The closer it is to paintings and drawings and that kind of art, the core Copyright Act kind of creativity, the better your argument about fair use of that trademark. But I usually suggest that to artists that, you know, if you can't get permission, do you really need the mark? Is your art really about the mark, or is it about the scene? And if you don't need the trademark, then you know, why not exclude it? You know, if you can't get clearance for it or permission. You know, just avoid the possibility of litigation with somebody who doesn't want to be associated with your art, or thinks that they're it looks like they're sponsoring your art and they're not. You know, those are situations where the litigation costs may far exceed the value of having a mark, you know, in your work. But you can't avoid the copyright issues, and you know, there is a question of whether making photographs in web would really constitute fair use when you make, you take them and alter them. Again, we haven't really talked about fair use here in the copyright consequence, but or context, but that's a relatively complicated question. How far your protection there goes, whether it's worth not getting permission first, to do it. And then, the terms of service themselves talk about machinima and the fact that you have a right to make machinima, not necessarily with permission being required from a sim owner to do it. So, I would say that there are some question marks about here that might be different than just an ordinary copyright question with that. So, if you have a texture, let's say, that is full perm, you buy it from the store here in SL, what can you do with it? Well, the copyright answer is it depends on the license that comes with the item. And usually, creators provide you a note card that is the license that comes with the work. And so that, even though it's full permit, the license itself that you're buying may limit what you can do with the item. But merely the fact that it's full perm by itself doesn't automatically mean you can do whatever you want with it and make derivatives. Doesn't automatically mean that. If the texture is of a public domain work, so say for example it's a famous Da Vinci painting that someone made a texture out of, at least under US law, that's in the public domain to do whatever you want. There's no real copyright interest in that texture. But if I make my own texture here, and even if I offer it full perm, that doesn't automatically mean you can do whatever you like with it. And if I offer you a texture that has my trademark in it, again, without a license, which would spell out how you can use the mark, you may be infringing. Again, just the fact that it's a full perm texture doesn't automatically mean you're free to do with it what you wish. I would say it often comes down to what the licensing agreement is that's offered with the texture, either in the SL marketplace or as a no card in World, or in some other fashion that governs that. All right, well, it's 2 o'clock. Again, I'm sorry we started a few minutes late. I'm also sorry that Agenda wasn't able to make it today. I didn't hear back from her when I emailed her earlier today. I still have not, so it may be that she just got tied up today with something else. But anyway, I appreciate y'all coming. We do try and do presentations once a month. We will be working on our schedule for November and maybe December, depending on how the holidays go this year. If this has been helpful to you, please feel free, please consider donating to the Bar Association. The scales of justice behind you outside the courtroom are is available to make donations to the Bar Association. Keeps our sim going, and we certainly appreciate them. I will talk to Agenda. She has a different presentation than this that she covers for trademark law, and we hopefully be able to get her to come back and make such a presentation. So I will certainly talk with her. And Michael, no, I'm sorry, I was sort of last minute for me to prepare for this, so I don't have any other materials to hand out today, unfortunately. Well, as I said, I mean, I do teach this at the college level, this topic, and I practice trademark law, so it's not unfamiliar. I think if I had to cover, I don't know, like family law issues or, an area of the law I just don't know anything about it, I probably would look very much like a last-minute sub. Yeah, you can get married, or you can partner, and you can unpartner an SL. I had a number of attorneys that practice SL family law, divorce law, but I suppose. Exactly. Eek is the appropriate. Eek is the appropriate response to that question. Yep, not a problem. Thanks all for coming out. We do appreciate it. And yeah, there is all kinds of crazy stuff in this. I remember I talked to a lady that she had, I think it was a product in SL that simulated pregnancy years ago. And I just thought, okay. And I guess that if you can get pregnant in SL, then you probably need someone to help you birth whatever you get out of a pregnancy here. Hey. I guess if someone has to be able to write some code to make sure the baby comes out. I don't know. I don't know anything about that. Ay, ay, ay.